Mr. Johnston.
Thank you kindly. In his early years at the bar, G. Arthur Martin would spend 40 minutes of a 45-minute speech on the introduction and the last 5 minutes on the facts. He would trace the history of the jury system to a time before the Norman Conquest, and he dwelt at length on the sad fate of his client, pacing up and down in a jail cell for years, should the jury find against him. As one of our most preeminent criminal jurists, Justice Martin appreciated acutely the import of history and the difficult plight of the accused therein. I'm clearly not G. Arthur Martin. I hardly have 5 minutes left any longer, and we don't have to talk about Ethelred the Unready and his 12 thanes to appreciate that throughout the course of history, the accused has been the overwhelming underdog. History is replete with examples of kings and governments trying to deprive the people of the benefit of trial by jury. It's written right in the Declaration of Independence. It's cited in the English Bill of Rights. Thankfully, history has also had individuals attempting to safeguard the rights of the individual. I think about this court's decision in Saumur in Quebec, where Justice Ivan Rand talked about the implied Bill of Rights, or John Diefenbaker, the great jury lawyer and later Prime Minister, who passed the Canadian Bill of Rights. But both of those were subject to ordinary legislative repeal, and neither guaranteed nor safeguarded the right to trial by jury. So in 1982, when our Constitution entrenched the right to the benefit of trial by jury, that was a meaningful moment. But what does that term really include, the right to the benefit of trial by jury? This court has respectfully not deconstructed what that term subsumes or entails. It is the Defense Counsel Association of Ottawa's most respectful submission that the essential elements of trial by jury as it existed in 1982 must first be identified before procedures like peremptory challenges or rotating triers can be determined to be constitutional or unconstitutional if removed. Removing procedural protections and giving those powers to the judiciary appears inconsistent with the promise in Section 11F. It's as this court cited Justice Felix Frankfurter in Turpin when it said, wouldn't that be akin to imprisoning a man in his privileges and calling it a constitution? We know that the Ontario Court of Appeal talked about how the peremptory challenge has not yet attained that status of a constitutional right, although it has the status of a substantive statutory right. But the Ontario Court of Appeal doesn't make any reference to this court's jurisprudence in Turpin, in Stillman, in Lee. This court in Turpin confirmed that 11F is designed to protect the rights of that underdog, the accused person, and to put corresponding obligations on the state to protect those interests. Just last year, this court talked about, at paragraph 28 in Stillman, how this is a right held by the individual, and that dimension is of the utmost importance. By eliminating the means of challenging the actions of the state through the elimination of peremptory challenges and rotating triers, are we taking a counterbalance and throwing it off kilter? In referencing this notion of what are the essential features of trial by jury as it existed in 1982, in our factum and in our condensed book of authorities, you'll see a reference to some U.S. Supreme Court jurisprudence, like Patton in the United States. Well, 12 jurors were found to be an essential element of trial by jury when the term was entrenched in their constitution in 1788 and 1789, respectively. That was confirmed last year in Ramos in Louisiana. You can't just make up what a jury is at any one point in time. We look at the High Court of Australia and its decision in 1993 in Cheadle and the Queen, where again they had reference to what did the term trial by jury mean in Australia in 1900 when that term was entrenched. And I'm just not making this up, though. Look at the steering committee document that we've included at tab 9 of our condensed book of authorities. Parliament was acutely aware that this notion of essential features of trial by jury existed. Well, what did trial by jury mean in 1982? We all talk about England getting rid of peremptory challenges, but that didn't happen until 1988. Nowhere in the free world did trial by jury exist without a peremptory challenge in 1982. This court in Barrow talks about how jury selection is invariably part of the trial, and how the scheme which then existed, or at least in 1987, had achieved an equitable equilibrium, and that any addition from an outside source would take that off balance. And here we are with this legislation, transferring all the power that the accused, the person to whom this right belongs, is being now given back to the judiciary.
Oh, thank you very much.
Thank you kindly.